In this courtroom, truth bleeds out in fragments. A woman stands trembling, forced to relive every scream, every strike. What began as a fight over a dog ends in a story no one inside these walls will ever forget.
I'll adjourn probable cause to November 13th, 2025, 9 a.m. On continued.
Thank you, Judge.
Thank you.
All right, to the judge.
Court calls case People versus Jerick Prince.
As false for the people.
Your Honor, Michael Gaddy, Assistant Public Defender, on behalf of Mr. Prince, who's here to my right.
Your name, sir? Jerick Prince. Thank you.
Your Honor, this matter, I did submit a green form. We're asking for a brief adjournment so I can go over the matter in a little more detail with Mr. Prince and maybe have him meet with our mitigation people.
Probable cause conference November 13th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls case of the People versus Alen. Is it Rinhackle?
Assistant Public Defender, Chinazikiri, I can really on behalf of Mr. Rinhackle. Thank you.
Your name, sir?
Alen Rinhackle.
Because we're going to put together some mitigation for the people to consider.
All right. Probable cause conference adjourned November 13th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you. Thank you, sir.
Okay. It says it.
Court calls case of the People versus Emanuel Rhodess.
As false for the people.
Assistant Public Defender, Chinazikiri, I can really on behalf of Mr. Emanuel Rhodes. Mr. Rhodes, state your name for the record.
Emanuel Rhodess. Thank you, sir. How are you doing?
Judge, we want to set this matter for exam, please.
Discovery is complete.
To our knowledge, Your Honor.
People have their witnesses available the 4th.
Track that day.
Preliminary examination in person November 4th, 2025, 9 a.m. That's before Judge Freshour.
Okay.
Bond continued. Thank you.
Thank you so much, Your Honor.
Court calls case People versus Alen Rogers.
Assistant Prosecuting Attorney to the People.
Good afternoon, Your Honor. I am Rinhackle Glenn, I would like to request permission pursuant to Michigan Court Rule 8.120 under supervision of Assistant Public Defender Stephanie Cannon. I am asking for an adjournment on behalf of my client, Mr. Rogers.
Want me to rule on your motion?
Yes, please.
No, it's okay. You're good. You just were speeding ahead. Said, I'm going to do all this for my client. Get him out. All right. And you are from where?
Detroit, Michigan?
Detroit?
Yes.
Okay. And where do you go to undergrad?
Clark Atlanta University.
Clark. So you're, okay. Well, then I just have to let you practice, I guess. And you're at Cooley Law School?
Yes.
Fantastic. All right. Permission to practice is happily granted. All right. And now you go ahead.
Okay. I am asking for an adjournment on behalf of my client, Mr. Rogers.
All right. Sir, can you state your name?
Alen Rogers.
All right. Fantastic. I'll grant that adjournment. November 13th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
All right. Thank you, Mr. Rogers. Court does call the case People versus Jesse Rogers.
As false for the people.
Michael Gaddy, Assistant Public Defender, on behalf of Ms. Rogers, who's approaching judge. State your name, Ms. Rogers.
Jesse Rogers.
Thank you.
Your Honor, I have submitted an adjournment request for Ms. Rogers is seeking an adjournment to retain counsel.
Okay. How much time do you think you'll need to do that, ma'am?
I would like to do it today, so not too much time. It wouldn't take much.
You're going to retain somebody today?
Well, I would like to as soon as possible. I'm capable of doing that as of today.
Okay, gotcha. Okay. I'll adjourn this then to November 6th,
Perfect.
2025, 9 a.m. Bond continues.
Thank you.
There you go. Take care.
Online. Court calls case People versus Lloyd Sanders.
Chairman, Adush, on behalf of Mr. Sanders, who is in Wayne County custody, Your Honor, I don't believe a writ was done on his case. I did talk to him and let him know.
Probable cause conference November 13th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Ashley Shepard.
Court shall please sit. Assistant Public Defender on behalf of Ashley Shepard. Ms. Shepard, please state your name for the record.
Ashley Marie Shepard.
Thank you.
Thank you, Judge. According to the notes in the file, it looks like we are working out some mitigation information for Ms. Shepard. If we could have 3 or 4 weeks, that would be greatly appreciated.
Probable cause conference in this matter will be adjourned to November 20th, 2025, 9 a.m. Bond will continue.
Thank you, Judge.
Thank you, Your Honor.
Thank you. Court calls case People versus Deontay Smith.
Assistant Public Defender Donovan Lee on behalf of Mr. Smith, who is approaching from my right. Mr. Smith, could you please give the court your name?
Good afternoon, my name is Deontay Smith.
Yeah.
Should have a plea form. I did have one.
This is going to be a no contest plea.
Yes, Your Honor.
Waiting for a copy of the form. What charge?
Receiving and concealing 200 to 1,000, Your Honor.
And then upon that plea, count 1 would be dismissed.
Yes, Your Honor.
Correct, Your Honor.
And was there any other parts of this agreement?
No, Your Honor.
All right. I'll sign off on the form once I see it. May I have him sworn?
That's right. You solemnly swear to affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth, so we got.
Yes, ma'am.
Lower your hand and state your name again.
Deontay Smith.
All right. Sir, it is this court's understanding that you are going to plead no contest to the charge of receipt and concealment of stolen property 200 to 1,000. Correct?
Yes.
That's a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. Do you understand that?
Yes.
All right. Do you understand what a no contest plea is?
Yes.
All right. 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Correct.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Correct.
Basis for the no contest plea?
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
No contest.
And you understand that by pleading no contest, you will not have a trial of any kind?
Correct.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No time.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Correct.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes, sir.
All right. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 25286. Any objections to the court having reviewed that report?
None from the defense, Your Honor.
No, sir.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you if between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any sentence evaluation or recommendation. The court would not be bound by that, and you would not be entitled to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which...
The judge brings the witness back to the stand. She tries to stay calm, but her voice breaks as she recalls that night. Stevenson had grabbed the family dog, beating it with a belt. Each strike louder than the last, each cry from the animal cutting through the room. The prosecutor asked what was going through her mind, and for a moment, she can't answer. The silence says it all.
led to this plea?
No, Your Honor. None known to the defense, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be November 12th, 2025, 9 a.m. That's before me. Bond will continue.
All right, thank you. Thank you, Your Honor.
Thank you. Court does call the case People versus Emanuel Sneed.
Assistant Public Defender Rinhackle appearing on behalf of Mr. Sneed, who's appearing via Zoom. Mr. Sneed, will you state your name for the record?
Emanuel Sneed.
All right. I have before me that he's going to plead no contest to the charge of operating while intoxicated, second offense.
That is correct.
That's correct. In exchange for the dismissal of the third. That's absolutely right, Your Honor.
All right. That's the court's full understanding of the agreement. All right. Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. State your name again for the record.
Emanuel Sneed.
All right. Mr. Sneed, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is you're pleading no contest to that charge. That is a misdemeanor, punishable by up to 1 year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, sir.
Court could also order community service and any rehabilitative services the court deems necessary. Could order your vehicle immobilized. Could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
And do you understand what a no contest plea is?
Yes, sir.
All right. Did I ask him to plead? And so, sir, to that charge, how do you plead?
No contest.
All right. I do have to advise you that a no contest plea does mean that you're not further desirous or wanting to contest this case, and that advise you that the court will treat you the same as though you had pled guilty. You understand all of that, sir?
Yes, sir.
For purposes of the record basis for the no contest plea.
Lack of recall.
All right. And you still wish to plead no contest, is that correct, sir?
Yes, sir.
You understand that by pleading no contest, you'll not have a trial of any kind?
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Or had it signed on your behalf?
Yes, Judge, I did
Yes.
provide a copy to him and he gave permission for me to sign that on his behalf.
All right.
Reviewed that with
Is
him.
that correct, sir?
Yes, sir.
Do you have any questions regarding any of those rights on that form?
No, sir.
You understand that you're waiving or giving up all those rights that are on that form?
Yes, sir.
Has anybody promised you anything other than what's been stated there here today on the record to get you to plead?
No, sir.
You also understand, so you're giving up your right to appeal, all right? Are you on probation or parole?
No, sir.
All right. Has anybody threatened you or coerced you in any way to get you to plead?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
Court has been provided and has reviewed Pittsfield Township Department of Safety report for their case number 204071. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
All right. Sir, well, based upon a review of that report, court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of the offense. The only thing I do need, because of what's contained in there, counsel, you stipulate to the prior.
Yes, Judge.
Very good. All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between now and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that you would not be entitled to any sentence evaluation or recommendation to the court, and the court would not be bound by that. And you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Judge.
Will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
November 12th at 9 a.m.
November 12th, 2025, 9 a.m. Before me.
Your Honor, a couple of things regarding that. Mr. Sneed resides in Florida. I obviously have discussed
On
with.
purpose?
I think so. Sounds like he likes it.
He likes it there? Okay. All right, whatever.
So I did inform him he's going to need to contact probation. I've also discussed with him the mandatory 5 days jail. I wanted to ask the court would he be allowed to appear via Zoom for the sentencing? And then I've talked with Ms. Parney and Ms. Parney specifically about allowing potentially for him to report at a later date to serve that time during the course of probation. But I just wanted to see what the court.
You talked to them about that? What'd they say?
They didn't give me a solid answer.
They didn't? Why? Because there's no telling what I'll do?
I mean,
is that what
that might have been like the gist.
Really saying?
Yeah, a little bit. But I just want to make sure Mr. Sneed's complying with whatever you were asking.
He needs to comply with that. We'll work that out with sentencing. Probably best to address that. Have it addressed to Miss Parent or Miss Teresa Plar.
Okay. Is he allowed to appear via Zoom for the sentencing? Well, once they make that request.
Why is everybody pushing? I need the request made. I will understand it.
Okay.
My staff will. We will.
Okay, understood.
All right.
Thank you.
Thank you. Bond continued. Thank you, sir.
Thank you, John.
Court does call the case. People versus Michael Stone.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Stone. Mr. Stone, can you unmute and state your name for the record?
Michael Stone.
Your Honor, we're asking for an adjournment. We got new contact information. Looks like today for Mr. Stone, there is a misdemeanor offer extended. I just need some time to talk that through with Mr. Stone.
November 13th, 2025, 9 a.m. Bond continued.
Okay.
Thank you, sir.
Thank you.
Yep.
Court calls case of the people versus Justin Strait.
Vehicle for the people. First time.
Whose case is this? No, I'll wait. Oh. Look. You don't worry about it.
Okay.
It's all Cannon's fault. Okay? You're good. Even though I had to wait. I know it had to be Miss Cannon delaying. Go ahead.
I am Rinhackle Glenn requesting, I would like to request permission pursuant to court rule.
Didn't they? She didn't talk to you about anything. You're good. Don't worry about it, Mr. Starr. She didn't talk to you about anything, did she?
What did I do? It was quick. It was quick.
No, geez, oh Pete. This gets so well. No, she didn't. You know what? You know what? You need.
Says it could be more than once.
What?
If you read that little court rule,
it could be more than once, but it's really up to the judge that I only need it once per session. And she was just up here. Do not try to cover for what you did trying to send her up here to get her head chopped off. Jeez, Cannon, protect your intern at all costs. You're good. You've already asked permission. I am I am so happy I was able to grant it. So you can just go ahead, counsel.
Thank you. I am asking for an adjournment on behalf of my client, Mr. Strait.
Here's no objection. Probable cause conference will be adjourned. Mr. Strait is like, I don't know what was going on. November 13th, 2025.
Actually, Judge, our client.
Oh, so that's not good enough? No, go ahead.
No, our client has something else to take care of on the 13th as well as the 20th. So we can please have a date.
Please.
After the 20th. Please.
You needed. You need a date after the 20th.
Yes.
Set it. Then I will set it. That was very nice how you asked, counsel. Unlike your supervisor. I will adjourn this out to November 25th, 2025. That's a Tuesday. That will be it. No, that will be at 9. Right? That is at 9 a.m. You may.
Man, will you clarify for my benefit whether or not the defendant is currently testing or required to test?
I think that he is testing. His last test that I have here was October 20th.
Yes.
You did today too?
I did Monday, and I got a call Sunday from my number.
Okay.
I
So
went
the
down
last,
Monday.
gotcha. So he's testing because the last test I have a report of is the 20th.
I have a
And
report.
no, you're good. You're
Thank
good.
you. Thank you.
You're good. You're good. That's people start talking. That's how they get in trouble. And then their attorneys got to argue because he went to jail, and then it's a big old mess. You're good.
Okay.
You okay? You relaxing?
I'm good.
Because you stressed me out and you did her too. You're welcome. His bond will continue with its condition. Thank you, sir.
Thank you.
Oh, now she's coming up. Yes, you may approach. Geez, oh no, wow. No, she just launched. Didn't know what to do. Lee was about to draw down on it. It was a mess. I told you, Cannon, protect your intern at all costs. Court calls the case, People versus Leo Stringa.
And on behalf of Mr. Stringa. Mr. Stringa, can you please say your name for the record?